afternoon. My name is Oliver Westmoreland. I am an OSC registered level 3 immigration advisor and I am senior immigration lawyer at GSN Immigration. Please subscribe to our YouTube channel and click on the bell icon so that you can continue to watch our extremely interesting videos about UK visa and immigration advice. My topic today is, well, a dual topic if you like, spouse visas and civil partner visas. Before anything else, I'll tell you what these mean in case you don't know. Spouse is to do with marriage, which is a relationship between man and woman, an official relationship between man and woman. Civil partnership, now, it could be a relationship between same-sex people or a man and a woman. So civil partnership can be either spouse is always man and woman at the moment, but it keeps changing, so you never know what's going to happen next. A person in the UK who is, now here we have a fairly complicated list, either a British citizen, someone who is settled. Settlement comes in different styles, different ways, different types. Someone who's in the UK and is settled. Someone who's in the UK with protection leave. This could be leave as a refugee, or it could be leave as a holder of humanitarian protection. Could be someone who holds pre-settled status, but be careful with this. The pre-settled status must be qualifying. Basically, this means that it must be based on a relationship that started before 31st of December 2020. If you're in this situation, you might want to get advice from a lawyer. Other categories, well, I was going to say obscure to an extent. Turkish business person, someone who holds leave as a Turkish business person. This is a rather old category, but it still exists. No new entrants are possible, but it still exists for some people. And finally, somebody who holds leave as a stateless person, somebody who holds no nationality. They can act as the expression goes, a sponsor under the relevant law. The relevant law is called Appendix FM. Appendix family member. This is a fairly large chunk of the excuse me, of the UK immigration rules. It provides the various rules for such a partner application. Do know that in many cases the application is made from outside the UK, but in quite a lot of cases it's made from inside the UK. Both applications are very possible. The main difference probably is in the financial rules. Now, in every single case applying for a partner visa, you have to have and you have to show a genuine and subsisting relationship. I'm sure that most people know what the word genuine means. Subsisting is a special word probably invented by the Home Office. I think it means ongoing, like today. Genuine and ongoing today. Financial requirements. If you're a keen student of immigration law, you know that it went up a few months ago to something a bit higher than it was. The basic financial requirement is that earnings must be at least £29,000 before tax. Earnings can come in from different things, salary, earnings from a company, self-employment earnings, there are different possibilities. Do know, older rules where the requirement was only 18,600, so it took quite a, well, it looks like a big jump. It wasn't that big a jump really because it hadn't changed since 2012. It wasn't as big a jump as it looked, but it certainly looked a big jump. Under the old scheme, children, you had to pay extra. The more children you had, you wanted to bring, you had to pay extra. If you had 50 children, you were in a big mess financially. Although £29,000 looks a lot, there is no extra requirement for children, no extra financial requirement for children anymore. So however many children you might be wanting to bring with you, they don't cost anything. Well, they might cost in certain areas, but not in visa application fees. Now, there is a possibility, if earnings are not enough, you could use savings to partially make up the shortfall, or indeed fully make up the shortfall. If you had no salary that you wanted to be taken into account, you could use earnings to fulfil the requirements completely by themselves. It was always quite onerous. Under the older rules, it was 62,500. Under the new rules, it's a rather scary looking 88,500. So if you don't earn much salary but you've got loads of money in the bank, you still might qualify. Do understand something very important about this. If the applicant is outside the UK, they'll have to rely on the earnings of the sponsor in the UK. If the applicant is already in the UK, which is very possible, they might hold another visa of some sort. If the applicant is outside the UK, the earnings from the applicant and the sponsor can be taken into account. So in that way, it could be easier. Just one little thing, I'm going to come to this in a bit more detail in a moment, but this is one of the rare exceptions to immigration principles. Potentially, someone can be an overstayer in the UK and apply for leave to remain as a partner. This is a very rare thing, rare exception to the rule, because the basic rule is to apply for visa B, you must hold visa A. This is one of the rare exceptions. We should come to that in just a moment. Accommodation must be adequate, must be big enough, I suppose you might say. There are very specific, not just rules, but laws. Housing Act 1985, there are actually laws to say how much space you need for a couple, how much space you need for other family members. The applicant must probably give good evidence that the accommodation requirements are met. If a very clever lawyer who's preparing this application, they might even get a chartered surveyor to make a survey of the property and make sure that there is sufficient accommodation for however many people are coming to live there. As I say, this is something which is embedded in English statute law. Finally, there is also English language requirement. Now, the English language requirements vary to some extent, but the basic requirement, the first requirement, first application, applicant must satisfy A1 English language requirement, and then on extension, they must satisfy A2. So that's pretty much it. That's the basic rules. But don't forget, these visas provide a route to settlement. If everything is good, everything is perfect, if the relationship stays together, very important, if the financial picture holds together, accommodation is still good, there is a 5-year route to settlement if everything is good, everything is perfect or near perfect. However, I did mention that overstayers potentially can apply for partner visas. I think it's because it's family application, the law is more liberal. It engages concepts about human rights and family life, and if you want to be technical, Article 8 of the European Convention on Human Rights. The law is really much more flexible. If an overstayer can submit a strong, compelling case, and especially if there are children, application could succeed. Can happen. It doesn't always, it's not necessarily easy, but it can happen, can succeed. But in that case, the applicant goes on to a 10-year route to settlement, not 5-year route to settlement. That's the basic scheme. I'm sure you've got some questions, Mr. Shah.
I would like to ask about the English language requirement, please. What if someone just cannot pass an English language test? Are there any exemptions to it for entry clearance?
What kind of reasons? Do you mean like health reasons?
Yes, if someone have health reasons.
Yes. If someone can get a medical practitioner to attest that because of their medical condition, like a psychological condition or something like that, they are unable to pass such a test, that could get them exemption from the English language requirement. But really, that is pretty much it. If the person is someone who's just not good at learning languages, and I mean, we know from common experience, when you get to the age of 50 or 60, your ability to learn a new language declines very sharply. If someone just doesn't have the intellectual skills or ability to learn a new language, I think they are stuck unless they can show real illness.
Okay. Thank you. And One of the very common questions we get asked is having a visit visa refusals. A lot of people try for a UK visitor visa. They don't know how to prepare a great application, and there's a refusal. In that case, would that refusal have any negative impact on their entry clearance for a spouse visa?
I would say probably not. Not unless it's something absolutely awful, but probably not.
Brilliant. That's good. In regards to accommodation, let's assume the sponsor is a gentleman. He lives with his parents, and he's wanting to sponsor his wife to come over to the UK and live with him at the same house. Would it be a good idea to include a supporting letter from the parents to say they have no objection for the daughter-in-law to come and live there?
Yes, I think it would be a good idea. Don't forget something very similar if you live in a house of multiple accommodation. You can get a supporting letter from the landlord, but that is not necessarily enough. And I think the scenario with the parents looks a bit dodgy. If I were whoever was preparing the application, I would get a report from a chartered surveyor who will go through the property and explain how it works. There's nothing against it in the law, but I think it's going to be more convincing a letter or a report from a chartered surveyor in addition to a letter from the parents.
Fantastic. Going back to the financial requirement is one of the backbones of this application and must be met. If someone doesn't have as much savings as you mentioned, for example, £88,500, however, they have good amount of savings and they are working and have some income from their job, can they combine the two?
Yes, they can. There's a medium complicated mathematical formula. Yes, they can combine the two.
Fantastic. And the savings amount, can it be gift from family?
If it's a properly attested gift, yeah. But I mean, in any case, you will have to have held the savings for at least 6 months. So a properly attested gift, which is 6 months old, it should qualify.
So they will have to declare the source of
well,
these
they will have to
savings.
declare, but there should be some sort of legal document, like a deed or something like that, from the person who gave the gift, like parents or relatives or whoever it was.
Brilliant. Okay, that's great. And you mentioned that the financial requirement at the moment is £29,000.
Yeah.
Per
year before tax.
Per year before tax. Fantastic. This is applicable even though there may be one spouse and kids, and there is no limit on number of kids.
You can include as many kids as you want. I don't recommend it, but as far as that part of the law is concerned, you could.
Brilliant. And does it also include stepchildren, if there are any?
Yeah, it can do.
Okay, brilliant. Because often there are couples who have kids from previous relationships, perhaps, and they want to move them along.
Well, you may run into the sole responsibility laws, which are a bit funny. If the other parent is alive, the parent of the child who is with the child might have to prove to a good standard that they have what is called sole responsibility. It doesn't mean that quite literally, but it means that they have to have a very large proportion, they're in charge of a large proportion of care for the child. They might have to produce evidence about that. If the other parent is alive but completely out of the picture, probably doesn't matter. But if the other parent is alive and still around, then it's going to be harder. The parent of the child who is coming with the child must show with good documentary evidence that they have, as the legal expression goes, sole responsibility for the dog. It doesn't mean quite 100% responsibility, but it must be a high level of responsibility for the child.
Sure. Thank you so much for elaborating on that. It's a very important topic for a lot of the viewers. Another question, and probably my last question for this topic, is there any fixed length that the relationship must exist for before someone gets married and apply for a spousal visa?
I wouldn't answer that question with a yes, but I would put it cautiously. If someone suddenly gets married to somebody and there's no evidence about what was going on beforehand, it could look a bit dodgy, couldn't it? I mean, you would normally have some sort of contact. I mean, some countries have
True.
got different cultures, some countries have arranged marriages and so on and so forth, but you would expect some level of interaction between the two people before they got married. I'm not going to put a figure on it, but you would think probably in most cases a few months, wouldn't you? If there's just nothing, say, oh, we just got married, and there's no history to it, it looks a bit dodgy, might get accused of a false marriage, a fake marriage.
Sure. So it's a good idea for the couples to put together some information related to
Yes,
their
I mean,
relationship.
if it's an arranged marriage, then the evidence will be different. But I think you really need some sort of history for, I would suggest, at least a few months.
Great, brilliant. Thank you so much for talking about this topic in such detail, and I'm
My
sure
pleasure.
lots of people will find it useful. Thanks a lot again.
You're welcome. See you next time.
See you soon.